Good morning. So we will start our discussion now. How is the question paper? How was it? Very nice. It was engaging. The whole idea of our question paper is, am I not audible? Am I audible? Priyanka? Mohit? Yes. For mic it is audible. I think I will raise my voice. We don't have speaker here. This is for online. People are also attending online. So yes. Actually, she thought that my voice would have got amplified. Yes. So she thought my voice would have been amplified, but it is actually for those who attend discussion online. So this is the second test, and we'll go for the discussion of second test. And as far as the first question is concerned, the most part in Indian governance, the president is the formal holder and the ceremonial head of the nation. The prime reason for the need of president in India is, so the fundamental idea of this question is that in mains you have comparative constitution. From 2018, they have been asking questions from comparative constitution in mains. And of late, there are also one or two questions in prelims where comparative constitution is also being introduced. Most of us believe that president in India is basically a symbolic authority. Is president of India a symbolic authority is what my question is. So this is actually, when we discuss these kinds of areas, president, executives and other areas are also as having lot of scope for mains too. So, but we are not going to discuss mains, prelims and all. But when we take up a concept, it is good when we discuss it in a comprehensive way. So the whole idea is that Indian president is not merely symbolic. Indian president, unlike British crown, is not symbolic, whereas he has his own functional roles. And what is that functional role? Most of the books what we read, we understand Indian president to be symbolic, nominal, de jure, or head of the state. But actually Indian presidents, the idea of the constitutional makers is not that. The idea of the constitutional maker is that Indian president will play a very, very effective role in protection of the constitution. If you take 2000, please, slowly. You can go there, you can go. Okay. So, the idea of, in 2017 or 18, you had a question. Which of the following is the protector of constitution? There was Supreme Court, there was president, but the UPSC key was president, remember? Okay, if you take Subhash Kashyap's presidency, there is a separate book called as Indian Presidency. That was a book written by Subhash Kashyap, not Indian Constitution or Parliament. There you would have justified that Indian president is the protector of constitution. So the whole idea of establishing the functionary of Indian president is that in case of exigencies, he will ensure that the constitution does not fail. He is actually the last authority who will protect the constitution. So that is the design of Indian president. When you see it from the discretionary powers of Indian president, you take Article 86, you take Article 78, you take Article 112, you take Article otherwise 75. Everywhere Indian president has been given lot of discretionary powers. But what we understand Indian president is that Indian president does not have constitutional discretion. He has only situational discretion. Actually, that is wrongly understood. That particular statement is for comparing Indian president with that of governor of the state. Governor of the state has constitutional discretion, whereas Indian president does not explicitly constitution confirm discretion. But it is his duty to protect the constitution. That is the reason when if you understand various jurists who speak about the position of Indian president, they say, what is the ground for impeachment of president? Few ticklish questions they have not kept. What is the ground for impeachment of president of India? Violation of constitution. And most of the provision says it is the duty of Indian president to constitute the Council of Ministers or the whole team. It is the duty of the president to ensure that the annual financial statement is laid before the House. It is the duty of the president to summon the House. What if the president does not, Prime Minister does not want to summon the House between 6 months? Does not the president get an extraordinary power to summon by himself? That you would have studied in Lakshmikant. The same situation. What if the Prime Minister or the Council of Minister refuses to put an annual financial statement or budget in the month of February or March? What is the remedy available for us? And finance is the engine. So these are the situations where these are all constitutional deadlocks. Why is President given the power of Article 143? Refer it to the Supreme Court. Why is President given power under 103 to disqualify a member of Parliament in consultation with the Election Commission? Can you understand what I say? These are a little higher level of understanding, but I would only advise you to understand it, not only for prelims utility, but also for mains or also for understanding things. So Indian president is not merely symbolic. Indian president has his own functional role, assuming the Prime Minister does not want to file annual financial statement. Then the president can even go to an extent of referring it to the Election Commission for disqualification. Assuming the president does not want to, assuming the Prime Minister does not want to go for Prime Minister does not want to go for 6 months of reassembly, then he can definitely go for it. There are active presidents like K.R. Narayanan who have rejected the request for 356. There are active presidents like Jail Singh who have rejected, withheld the bill and said he will not pass the bill. There are active presidents like Pranab Mukherjee who have spoken on Republic Day that hatred among community is going to be very dangerous for community at large. So the Indian president is not merely symbolic. The whole idea of having presidentship or the whole idea of having the post of governor is only to protect the whole system, what the constitution envisaged to do. So we all criticize governor as a representative of the central government and he is an anti-federal entity. Actually, what is the role of governor sitting there is to only to ensure that the security, the unity and integrity of India is ensured, or to enforce the constitution, and if in case of failure, he will prompt it. Assuming 356 is being passed, on the top, governor. Then comes Council of Ministers with Chief Minister as the head. Then below that comes Secretariat and Directorate. All Secretariat, can you understand what I say? All Secretariat and Directorates are manned by IAS officers. IAS officers are appointed by the President. Governor is a representative of the President. Assuming a particular state chief minister does not want to cooperate with the center, at one stroke, India can become a unitary system. So that is the whole idea of having governor at the states. Similarly, the idea of having president is not symbolic. He has certain functional roles. This can be a mains question also. So this can also be a prelims question. So this is the idea of this question. For most part of the Indian governance, the president is a formal power holder and a ceremonial head of the nation. The prime reason for the need of president in India is, what is the answer? Meet the exigency of parliamentary system. Consider the following statement regarding the Consider the following statement regarding, is there any doubts? I will just, okay, done. Consider the following statement regarding the executive. The executive executes both the laws made by the legislature and decisions made by the judiciary. Yes or no? Yes. The permanent executive is responsible for the government policy. So there are two types of executive. One is the permanent, other is the political. What is the difference between permanent and political? Permanent is, political is that holds office by virtue of mandate given by the people. And permanent executive are those who take civil service as a full-time career. Not only IAS officer, even a clerk. Okay, so permanent executives are those who hold office as a full-time career, and they are professionals. And this relationship is the base of parliamentary form of governance. The relationship between political executive and permanent executive is what the basis of parliamentary form of government. We call it as amateur professional relationship. Have you heard about this word? Amateur professional relationship. So the whole idea is that amateur are those ministers who have the mandate of people. Professionals are those civil servants who have cleared the examination and holding the post. So amateur professional relationship is the basis of parliamentary form of government. If at all somewhere these kinds of questions come, you must understand this is the basis of it. So answer for this is C. C, no, B. A only. Only A. Day-to-day business, permanent executive. Yes, Priyanka. So next question. Consider the following statement regarding the veto powers. The President of India can use a suspensive veto for a constitutional amendment bill. No. So, the President has the power of disallowance or return for reconsideration of a money bill of the state legislature. Both no. 201. And as far as suspensive veto is concerned for constitutional bill, which article? Which article says? You can say that article 111 is about assent to the bill. If you read 111, you will only understand he cannot return a money bill. Yes or no? 368 says that he shall give the assent. When was it being made compulsory for him to give the assent? 24th Amendment. 24th Amendment made it compulsory. So it is by virtue of 24th Amendment. Additional facts, you can just note it down. One thing I would only request you that if I speak something with additional facts, you must keep your mindset that you are knowing something new. So the general tendency I have seen here at Delhi is that if something more is said, you yourself reject stating that this won't be asked in UPSC. Oh yeah, that is actually, you cannot confine yourself to Lakshmikant and you know that. So you have to go an extra mile. And all of us read NCRTs, all of us read Spectrum, all of us read Kochang Liang, all of us read NCRT, but all of us does not clear. The fact is that you need to go an extra mile. It is as simple as that. So do not get, what to say, the defense mechanism of individuals will convince you that we don't need to know much. The general idea of UPSC is that you must be jack of all trades. When you read something, somebody is going to add to your knowledge. You must be matured enough to understand, okay, we'll add to our database. That's it. So that is the best way to clear UPSC. Coming back to this. Yes, coming. So 24th Amendment says, and if you take Article 201, it categorically says, when the bill has been reserved for the president and the president assent has been given, sent for the president assent, the president can send it for, either accept it or withhold it. And 201 categorically says money bills cannot be sent back to the state legislature. The fundamental idea is this. In the last class, I told you, every provision of the constitution has logics. Why you cannot send a money bill for reconsideration is that it will result in a process where it will disturb the functioning of the whole system. Finance is the fuel to the engine of governance. It is the statement of Kautilya fundamentally. So he says it is for the mission of government runs with the lubrication of finance. So the constitutional makers does not want it to be sent for reconsideration. So that is what the whole idea of that is. Yes. Can reserve the money bill for president, but president cannot send it for reconsideration. So that is even in the parliament, the president can withhold the money bill. Okay, why withhold permission is given? Once if something is being withheld, what is the idea behind the power of withholding? Do you know? The idea behind the power of withholding is to create a public opinion. If president withholds a bill, then it will become a discussion of And I was talking about president's power. Withholding power is one beautiful power. And most of us does not understand. I asked a question also. Article 86 is from American Constitution. Did you remember that question? I asked one question where I said Article 87 is from British. Article 86 is from America. Actually, that is a fact. No, that is a fact. The presidential power of sending a message to Parliament is such an strong power of president. Assuming president sends a message to Parliament and says, why you are not enacting a bill on criminalization of politics? Next day, it is going to be a huge issue in the newspaper. Every opposition party is going to take it up. So the whole idea is that it is a power derived from American president. So Indian president power is very high. That is why T.N. Seshan, previous chief election commissioner, wanted to compete for election of president and he got failed. He said Indian president has a potential of even becoming a dictator. But generally public opinion will prevail over it. That is the idea. Tell. You are asking some question. No. We'll come to that question. We'll go. Okay. I was just telling that. Okay. We'll come here. So answer this is neither one nor two. Which of the following commission recommend for the removal of governor by impeachment by the state legislature? It is Punchy Commission. Punchy Commission was constituted for deciding certain things on center-state relationship. Punchy Commission gave certain path-breaking advices on governor and governor's functioning. One of the greatest difficulty what we face with regard to the governor is that governor is the head of the state and also the representative of the central government. And governor does not enjoy sufficient independence like other constitutional authorities. Now there is a case pending before the Supreme Court of India, before a constitutional bench, with regard to the appointment and removal of governor of a state. The whole idea is that when you look into the concept of control over administration, the best control is appointment and removal. If you take other functionaries, the appointment is done by some authority and removal is done by some other authority. For example, if appointment is done by president for appointing an high court judge or a Supreme Court judge, removal is done by the legislature. If appointment is done by the executive, the removal is by the legislature. So the whole idea is that I will appoint you. I will appoint the class leader here. And the removal is by whole of you. Then he is independent of me, independent of any individual. But does the governor enjoy this particular situation? And this concept is called as doctrine of pleasure. Indian president has the privilege of having the doctrine of pleasure? We have to say yes with regard to three authorities. One is governor, other is attorney general, third is individual ministers. What is the doctrine of pleasure? Doctrine of pleasure is as simple as this. The appointment of an individual and removal of an individual is based on the pleasure of individual or a few person, and both are by the same. So when you appoint governor, it is on the recommendation of council of ministers, you will appoint the governor. On the recommendation of governor or council of ministers, you will remove the governor. On the recommendation of council of ministers, you will appoint the attorney general. On the recommendation of council of ministers, you will remove the attorney general. On the recommendation of prime minister, you will appoint individual ministers. On the recommendation of prime minister, you will remove the individual ministers. Only three functionaries in India falls under the concept of doctrine of pleasure. So Punchy Commission gave recommendation stating that doctrine of pleasure needs to be removed. Let the appointment be the council of ministers, but the removal be by the impeachment process by the state legislature. Can you understand what I say? So this is what Punchy Commission's recommendation is. And he also gave a lot of other recommendations such as localizing emergency. He said emergency should not be, the Article 356 has to be amended and should be said which are the areas where 356 can come. So that what will happen is, ultimately 356 cannot be misused. Jammu Kashmir, Naxal affected area, certain areas of Northeast. They must notify which are the areas eligible for 356. That was the other recommendation made by Punchy Commission. So, similarly, he gave a lot of other recommendations also. For example, another one important recommendation of Punchy Commission was that if you are going to amend something from concurrent list, enact on concurrent list, consult the state government before enacting in this concurrent list. These are the recommendations fundamentally given by Punchy Commission. Next we will go. Consider the following statements of the cabinet. Am I slow or should I increase my? How much increase? How many increase? Democratic institution. 1.5. Okay. This is another unique thing I experienced with Delhi. You want to go on the when you want to clear the examination, you are doing some other work. It is you want to clear the examination on the go. Okay. Actually, understand UPA. That is one thing where when people request me to give a shorter notes on governance, I refuse to do that. When I was taking, I understood this phenomenon when I was taking Subra Ranjan internal security and part of governance in 2018. When I issued the material, every student was happy. But the feedback which they gave is, sir, how can I read this much on Naxalism? Cannot that be for 2 or 3 pages? So from that I could, but this is not the phenomena outside Delhi, and this is not the phenomena just because majority is here, it is not right. This is not the phenomena of successful candidates. If you take successful candidates, they will know the fundamentals. They will know how to make out of fundamentals better answer. They will actually know better than you. So there is a popular saying in English, do little bit better than what you can do. If you can read for 1 hour, read 1 hour 15 minutes. If you can run for 1 hour, run for 1 hour 10 minutes next day. Slowly. So do little bit more than what you can do. So actually I'm not for reduced discussion, but since we are new, I will just listen to you for now. 1.5. Okay. Slowly. So consider the following statement. The Prime Minister constitutes committees of cabinet and sets out specific functions assigned to them. Yes or no? Correct. There were 10 cabinet committees constituted by? Yeah, wrong. Answer is A. Consider the following statement. When the subject of a case concerns more than one department, the decision can be taken under the authority of the president. Yes or no? Then who will decide? If not president. Common sense. Cabinet. When there is, that is the way committee is formed. The cabinet will sit. Cabinet will decide on it. Okay. The Ministry of Cooperation is the newly created ministry by incumbent government for realizing the vision of prosperity through cooperatives. I don't want to read it in Hindi. You will again laugh for that. Prosperity through cooperatives. Answer is 2 only. Consider the following statement regarding pardoning power. The pardoning power has been conferred on executive to correct the possible judicial errors. Wrong? Okay. The Constitution precludes the pardoning power of the executive against the punishment offered by courts against its contempt. Wrong. Wait. Oh, yeah, and we heard you. The pardoning power has been conferred on the executive. Yes. It is actually, this question was taken because in Lakshmikant, you get contradictory statements. Lakshmikant says it has judicial power. If you go and read Lakshmikant inside, it will be in the pardoning power section. If you see it in president's function, it will say that it is a judicial power. Inside pardoning power, one line he has written it is an executive power because to correct possible judicial errors. And it is not Lakshmikant's statement. If you take D.D. Basu, the exact statement will be there, but it is a cut and paste there where you cannot understand with the fundamentals. So it is as simple as this. Executive is head of the state. Executives are elected. They know the pulse of the people. Whereas judiciary is not elected. Judiciary can take undue or not undue hasty decisions. To rectify it, world over, executives are given this power. Not only in India. So all the functions except ordinance making power, every function of president is an executive power. Ordinance making power is a legislative power of president. I will say like this. Will you accept it? Yes? Why? Why do you accept it? Because ordinance making power of President of India is a legislative power. Why do you say that? It is not exactly. It is only a coordinate power. No, I'll come to this. Because Article 123 says so. If you take the Bar Act, it is categorically the constitutional makers have said legislative power of president. 123. Ordinance making power. Rest of that, everything is an executive power. If you read D.D. Basu is very clear on it. Subhash Kashyap is very clear on it. So president is the executive. President is part of the parliament, not because he is a parliament member, but because he is a executive. Am I confusing? I will tell you, because these are all definite concepts which must you know so that you can derive answers. One of the greatest routes for success in preliminary is that you must be in a position to derive answers from the question. Why is President of India member of Parliament? Because what does Parliament in India constitute? 1, President, 2, Lok Sabha, 3rd is Rajya Sabha. Why is that? No, because India has adopted parliamentary form of government. In parliamentary form of government, the fundamental rule is that the executive should be member of the legislature. So that fundamental rule is being respected by our constitutional makers. So they have made him as the part of parliament. Can you understand why I say? Otherwise, all other ministers has to be a member of parliament or should become a member of parliament within 6 months. So that is the reason why President of India is part of parliament. So he being a part of legislature is by virtue of he being an executive. He having a pardoning power is by means of virtue of being an head of the state. So only power which you will cast upon the president as a legislative power is ordinance making power, because constitutional makers themselves say it as an legislative power of president under Article 123. If you take the Bar Act, you can find it. So the answer for this is 1 only. So next. That is not the part of question. Yes. Yes. Yes, it is not the discretionary power. It is on the advice of Council of Ministers. You know the answer. Yes or no? Yeah. Recently, the center has virtually conferred upon himself the plenipotentiary power under Article 312 of the Constitution. What is it answer? All India service. How many All India service are there in the Constitution? What are they? See, if I go 1.5, I cannot tell you very relevant information. In Constitution, IAS, IPS and All India Judicial Service is there. Yes. You take 312. Oh yeah, please, I will tell you. Allow me to tell. Okay, so that I can correct. But the problem is that I'm not marking at anyone. I'm just trying to. These are all certain fundamental problems I can find with students of present day. There are 3 constitutions, the 3 All India service in the Constitution, and there are 3 constitution on 3 All India service in reality. But All India service, IAS, IPS, Indian Judicial Service is there in the Constitution. Okay, 312. You take and read. Indian Civil Service has been rechristened as Indian Administrative Service. Indian police has been rechristened as Indian police. So this is there in the original constitution. 42nd Amendment brings in IJS, All India Judicial Service. And it has kept only in 312 and said, whenever you want, you can implement it. In 1960s, Indian Forest Service has been created by an act of parliament after the resolution of Rajasthan. So Rajya Sabha. After resolution by Rajya Sabha. Can you understand now? So there are a lot of micro facts within it. 3 All India Service mentioned in the Constitution. What are they? IAS, IPS, IJS. AIJS, All India Judicial Service. 3 are in force. One is IAS, IPS by virtue of Constitution mandating it. Third is IFOS. IFOS is by means of an act of parliament after the resolution passed by Rajya Sabha. Can you understand? What if the question comes like that? Okay. So now there is a possible question in prelims or in mains, All India Judicial Service, because there is an tug of war between executive and the judiciary going on as far as the judicial appointments is concerned. So All India Judicial Service is considered to be one of the most important alternative for the present collegium system. So central government is pushing on it. This is coming up on newspaper. That is the reason why I say, why do state government, central government take it so seriously when the Rajya Sabha does not want to do it? Can you understand? So Article 312 is about All India Service. Consider the following statement. The governor can summon, prorogue, and dissolve the house without the aid and advice of Council of Ministers. If the governor had reasons to believe that the chief minister and his or her Council of Ministers have lost the confidence of the house, a floor test can be ordered. Yes or no? What is the right answer? Only 2 is right. Nabeem Rabia case. Have you heard about Nabeem Rabia case? That has not become popular. Suddenly one day it will come in the newspaper or the exam. Then we all will know, but of no use. Operation success, patient dead. Okay, like that. Because Kokelo case is like that. Only in 2017 when I asked the question, we all were looking into what is Kokelo case. Prakash Singh case is like that. Only when he asked the question, what is Nabeem Rabia case? A very, very important case in the constitutional history. You all know SR Bomai case. Yes or no? SR Bomai case is about 356. Nabeem Rabia is also about 356. In Arunachal Pradesh, what happens in 2016 when the Congress government was toppled and then BJP government was restored there, the coalition of the BJP was restored there, kept there. They filed a case in Supreme Court. Supreme Court after 1 year said, reinstate the Congress government and go for a floor test. This was the dictum originally laid by Supreme Court in SR Bomai case. In SR Bomai case, they said, do not misuse the provision of 356. Whenever we want to reinstate, we will reinstate. But here in this case, we don't want to reinstate, but do not think that we don't have the power to reinstate. That dictum was followed in this case, where Arunachal Pradesh Chief Minister was restored, but again because of the diplomacy or the statecraft of our Prime Minister and Home Minister, Congress lost it again. So that is a very constitutionally important thing to know for 2 reasons. 1, the Supreme Court reinstated it. 2, that was a beautiful manifestation of clash between judiciary and executive. When they got reinstated, the BJP could topple the government by having at least 85% of the member, even the chief ministerial candidate, joining BJP, defecting Congress. Do you remember one time when Arunachal Pradesh ex-chief minister joined Congress, joined BJP and said, when I went to meet Mr. Rahul Gandhi, he was refusing to meet me, stating that his pet dog was not feeling well. Do you remember? That became very Assam. That time it happened in Arunachal Pradesh. So both of them went and met, and they given by Assam The statement was given by Assam Chief Minister. So that was a very constitutionally very sensitive topic to understand. Okay, so this is the answer for it. Answer is 2 only. Nabim Rebia. Rebia. Rebaa. So answer is the governor. So answer is 2 only. Entry 33 in list 3 under 7th schedule of the Constitution was introduced through 3rd Amendment. What is it? Farm laws. What is the entry? Not agriculture. Trade and commerce, production and supply, distribution of domestic and international products, then those other food items, food articles. It is a very big statement. That is the basis for bringing farm laws. Farm agriculture is in state list. How can they bring farm laws? Only quoting this entry, they have brought it. Can you understand? So the controversy is all because of this particular list. So the choices, I think you would have got confused. No? Very easy, sir. No problem. Consider the following statement regarding President of India and President of America. President of United States. Wait, somebody has that out, I think. One second. Yes. Yes. So President of United States is a real executive, whereas the President of India is a titular head. Both the President can seek re-election only once. Both the President can be removed from office through impeachment. Both the President has to sign the bill within 10 days of passage of... Wait, allow me to finish. Within 10 days of passage of the bill by legislature. So answer is 1 and 3. So pocket veto for an American president is 10 days. I don't want to waste your time on that. 2 and 4. Which of the following best describes collective responsibility? Delhi only. All the members of the government are unanimously in support of government policy. That is what collective sink or sail together. First is individual responsibility of the minister. Yes. No. Thank you. No. I don't want to know. Okay. That is both houses, not both houses. Fine. So we'll go. Let us not wait in these kinds of questions. Any doubts on that? Responsibility of minister to the president is individual responsibility. Both are for individual. There is a confusion. Again, people understand it this way. But there is another question. There I will explain that. So there are 2 aspects in Article 75. One is collective responsibility of Lok Sabha. Doctrine of pleasure is with regard to individual responsibility of the minister. Can you understand? There is that in Article 75 there are 2 aspects. One is collective responsibility, the other is individual responsibility. Okay. Sir, online this question option were misprinted. A and B are same. Okay. Yes. I will tell you. If I will just. Okay, Priyanka, the mark is for you. Okay. Then my idea is there is one question mistake here, one repetition of question. You please, okay, forgive us for your good. Okay, because sometimes it happens. Because yesterday night it was not like Tamil Nadu where we used to sit after 10 o'clock and work. Here 8:30 Xerox shops close. Okay, but at Tamil Nadu we start work only at 9 o'clock. Then we have our own printing whole system. Here it is very difficult. Yesterday we finished the question paper at 8:30 and then we requested our Xerox machine friend to wait and he waited. So that is the difficulty here. What was she asking? Ministers, yes. Who can become a minister? Anybody can become a minister, but he must become a member of parliament within 6 months or he must already be a member of parliament. So the qualification for being minister is the qualification for becoming a minister. So you must cross 25 years or 30 years, whatever it is. And they don't distinguish between member of Lok Sabha and member of Rajya Sabha. Elected members or nominated members. So anybody can become a member. So that is the fundamental rule. Can anybody can what? He would not be responsible personally to the Lok Sabha as a member of Rajya Sabha, but as a minister he is answerable both Lok Sabha and Rajya Sabha. Other ministers are also answerable to both Lok Sabha and Rajya Sabha, but who has the right to remove is only Lok Sabha. And when the Lok Sabha removal motion comes, Rajya Sabha ministers cannot vote on it. 2.5. Yeah. You have any doubts? You want to clarify any doubts? Yeah. So answer is all the members of government are unanimous in support of. I think I'm going to pay for you to attend vision test. I'm just joking. Tell me. Who are all the members of government? Only the ministers. Yes. Okay. What do you want me to explain? D option. What is collective responsibility? Collective responsibility is a fundamental concept of parliamentary form of government. So the whole idea is like this. I will tell you if you are very confused on the fundamentals of collective responsibility, I will tell you. People elect members of their representatives, and they in turn select a person, that is Prime Minister, who is having a majority among the elected members. And this duty of the Prime Minister is to achieve the concept of welfare state as envisaged in our constitution. The goal of Indian constitution is establishment of welfare state, that you can read it from preamble. Now, can the Prime Minister alone travel to achieve this? He cannot do. Now the Prime Minister can have his own team, because he need to work on home, he need to work on finance, he need to work on external affairs, he need to work on defense, he need to work on human resources and like on. And by means of division of work, you all will move towards this. And all these functions I alone cannot do. Then what I do is I go for division of work with effective delegation. I choose an individual who will take care of home. That is Home Minister. I choose an individual who will take care of, what is this? Something, finance, external affairs, defense, HR. So this is how the whole council comes. The whole council, the rule is that you must also be a member of parliament, because ultimately being a member of parliament, you can be answerable to the members here. And these members derive their authority from people. And when they sit here, otherwise, council of ministers are nobody than this. Yes or no? If you want an urgency for some reason, somebody from outside, you can have them. But ultimately, you are responsible to Lok Sabha. When assuming now, this is the whole understanding. So everybody is functioning in tandem. And one ministry alone is not functioning properly. What will happen to the goal of welfare state? It will not achieve. So you have to sail together so that the goal of welfare state is achieved. Can you understand the concept? So this is the whole logic behind collective responsibility. Now you have to sink or sail together means whatever the disagreement you have within the cabinet, you express. But ultimately decide in a way that all of you sail together so that welfare state is achieved. So now you read this statement. All members of the government are unanimous in support of the government policies, because it is taken out of deliberations within the cabinet. Who is the real executive of India? Who is the constitutional real executive? Council of Ministers headed by Prime Minister. When you all take a decision, you have to be unanimous on it. You can have disagreement within the room, not outside. That is the reason. If you are going to do it, if the finance minister is not going to be proper, I don't want to say that finance minister is improper. I just want to remove him. Rather, I will say your ministries are not functioning in tandem, so you all go out. That is collective responsibility. Can you understand what I say? So collective responsibility is such a simple concept. So collective, now read it. Responsibility of minister for his action. Yes, that is well within collective responsibility. The responsibility of council of minister to both those of parliament. No, because 75 directly bars it. Responsibility of minister to the president. That is individual minister's responsibility, part of collective responsibility. All the members of government are unanimously in support of government policy is the best answer here available. Yes. Consider the following statement regarding ordinance. The ordinance making power of president comes under the category of delegated legislation. No. What is delegated legislation? Delegated legislation is otherwise called as subordinate legislation, otherwise called as executive legislation. You can test by yourself in your phone later when you get time. Whatever act you know, you will have rules for it. Everybody must be knowing some act. Somebody knows Right to Information Act, somebody knows All India Council for Technical Education Act, somebody knows their own related acts. You will have rules. What are those rules? Rules are nothing but delegated legislation. Parliament, by virtue of not having sufficient time, sufficient expertise, and need for decentralization, will only enact a law, and they will empower the executive to make rules for implementation of the law. The rule should not go beyond the act. That is what delegated legislation is. That is a very important main topic. Okay, this is what ordinance making power is a legislative power of Indian president, not a delegated legislation. Okay, ordinance has power to limit the fundamental rights of an individual within the limits of constitution. Yes, answer is 2 only. We will go. Option 2, yes. Yes, why? Already reasonable restrictions are there. We don't say amending fundamental right. Restriction of fundamental right is already there. What was the ordinance? You tell now. What was the ordinance? During the COVID period, no ordinance. Yeah. I'm just joking, leave it. Okay, next question. Who among the following is the chairman of National Water Resource Commission? Are you sure? How many of you are sure it is Prime Minister? Oh, yeah. Yes, sure. Randomly, we'll understand it to be Prime Minister. Okay, Prime Minister is there, we'll put Prime Minister. Okay, Prime Minister. And what are the functions of National Water Resource Council? We have a national water policy. And this Water Resource Council has adopted it. And now it is only looking into the implementation of a national water policy and looks into increasing the national's water resources. That is the whole idea of that council. Why was it in question is recently Prime Minister convened a meeting of it some 4 months back. So for current affairs, I just wanted to have it. Consider the following statement regarding the President of India. The President must be informed of all decisions of the Council of Ministers. All decisions, correct? Yes, that is Article 78. The Constitution provides for the appointment of Prime Minister only proves a majority on the floor of the House. He will come inside, then he will prove his majority. Answer is 1 only. Consider the following statement regarding CAG. CAG and of India secures the accountability of executive to the Parliament. No doubt in it. The CAG has no power to enforce audit findings. Why wrong? CAG can only raise audit objections. He can only, what happened in 2G? Okay, what happened in 2G? Only said 1 crore and 81,000 crores is gone. That is what they said. He cannot have the right to enforce audit finding. Answer is 1 only. Parliament will only do. Then what is the duty of PAC? What was the question? CAG has no power to enforce audit. Yes, both 1 and 2. Let me check online. Any doubt? Sir, online this question option was misprinted. A and B are same. That is okay. No, that question only. That was the last. Yeah, I don't want a disagreement. The advocate of the state is appointed by the president on the recommendation of the governor of the state. Yes or no? Then how is he appointed? Governor by himself. The advocate general holds office till the age of 62. No, neither one nor two. Consider the following statement regarding the concurrent list under Schedule 7 of Indian Constitution. I think it is on off. Once again. Next. Agriculture is a part of concurrent list where both the union and state list can legislate. No, answer is state list. If the state law and subject listed in the state list contradicts the central law of the same subject, the central law prevails. Answer is 2 only. Okay. What? This. Wait, that is what I am just confused. Answer is D. If the state law on the subject listed in the state list contradicts the same subject, okay, then central law cannot prevail. It is only state law that will prevail. Answer is neither 1 nor 2. Well, next. Consider the following pairs regarding the dispute region and the concerned states. Answer is 3 only. Parwano. What is that? It is between Haryana and Himachal Pradesh. Sarcha is a place which is the conflict between Ladakh and Himachal Pradesh. Belgaum district is between Karnataka and Maharashtra. Okay, here answer is 3 only. Which of the following is true about environmental federalism? Second is also right. That is the problem in my Major Minerals Act. No, the problem is that Minor Minerals Act, state government have larger, when it comes to coal, when it comes to petroleum, the resource is that of the state government. But the extraction is dependent on the central government. And PESA Act, we gave the right to the panchayats, but the state government does not want to empower panchayats. So PESA Act is actually gone waste. And last is that, climate change makes the coordination essential. You may got confused, but mineral resources, then you have to. So, why is that? Funding pattern, there are 2 authorities. One is the state, another is the center. 2 authorities are there. 10%. I forgot the exact statistics. I will tell. I will tell you. State owns the mineral resources located within the territory. But, no, I will tell you, wait. But the center exercises effective legislative control over it. For example, very simple, if the coal in Assam region, the resource fundamentally is that of Assam, but you cannot extract it. And he has a doubt on minor minerals. I will tell you. My one example of minor minerals is the river sand. River sand is owned by the state government. What is that state environmental impact authority? Created by central legislation. Okay, and wait. Okay, and resources, even if the minor minerals are that of the state government, you have to get the clearance from Central Pollution Control Board, Central Environmental Authority. So, though it is owned by the state government, even the minor, Environmental Pollution Control Act applies. this Environmental Restriction Act applies. So there is an authority called the State Environmental Protection Council, which is fundamentally creation of central legislation. Okay, can you understand what I say? So how does it affect federalism? That is what a newer federalism is evolving, that is called as environmental federalism. Every year if you take, they ask you federalism, different questions from federalism in mains. Have you seen that? We all know either India is federal or unitary, partly federal, partly unitary. Last test I was discussing about how India is federation sui generis. Whereas now I just want to tell, there are at least 10 areas from where they can ask question, and every year they're asking. For example, in mains, except 2017, every year there is a question in federalism. Last year, federalism question was that CBI. In 2019, prior to 2019 election, CBI wanted to arrest the commissioner of West Bengal, and that has become a huge issue. That was a federal issue with CBI. Similarly, you have issues with regard to international relations, whereas states like Tamil Nadu, West Bengal, Assam, all of them takes up the relationship with the neighboring country and has a clash with the central government. You have federalism and judiciary, that was also asked. Federalism and local government, federalism and 356, federalism and governor. Okay, a lot of areas they have not asked. Federalism and internal security. Okay, NIA and federalism is another serious area where we have to see. So federalism is law, now COVID and federalism. Now another evolving concept is that environmental federalism. And there are other forms of federalism. You know what is cooperative federalism, what is competitive federalism. There is also another form of federalism which they have introduced for union territories. Can anyone tell the name of it? In Delhi case, they have coined a term. Supreme Court has coined a term for that kind of federalism, which is called as collaborative federalism, where they say even the governor is given power by the constitution. Governor cannot do whatever he wants to do because it is having a representative government at Delhi. That is a collaborative federalism. So that was given, that theory was propounded by judiciary, like constitutional morality or anything like that. So do not have a confusion that minor minerals are owned by the state and they enjoy ultimately. So minor minerals are restricted by states. So can you understand how this resource share is where state restricts the center? Answer is all. Duties that states have to respect the public acts, judicial proceedings of union and of every other state. Full faith and credit clause. What is the article governing it? 261, that is right, 261. What is doctrine of territorial nexus? What is doctrine of territorial nexus? Do you watch the question paper carefully? Every year there is one doctrine asked. Doctrine of federal supremacy. Okay, doctrine of repugnancy. Every year there is a question on doctrines. Do you see that, or I want to show you in the next test? In mains and prelims, one or the other doctrine of separation of power. Have you seen those questions? Just watch it from this perspective. So it is actually easy to predict mains questions of governance. Actually easy to predict prelims question of polity. That is what I was saying. Out of 20 questions, 18 questions can be touched, provided you must know polity from little different perspective. That's it. So doctrine of territorial nexus is article 1245, which says as simple as this: center can legislate at, parliament can legislate on union list, state can legislate on state list. And if the state legislates somewhere, for example, Aram IAS Academy is there at Tamil Nadu. I am starting an institute here. When there is a state legislation for some taxations or licensing, should I pay the licensing fee at Tamil Nadu for starting at Delhi? Yes, because it is a registered office at Tamil Nadu. So that is called as territorial nexus. Doctrine of repugnancy. Doctrine of repugnancy is all about clash between state list and central list. When concurrent list comes, so what will you do? So that is article 254. Doctrine of eclipse. Article 13 subclass 1. Okay, article 13. Doctrine of eclipse. And today I will give you, which we have released 2 years back in Tamil Nadu. I will also circulate among our test batch group. We have released one small ebook on doctrines that I will circulate whenever you get time. You can read those. Those doctrines you can effectively use in ethics paper. Doctrine of public interest. Okay, doctrine of pith and substance. Several doctrines we can use in ethics also for writing. Consider the following statement regarding enforcement of fundamental rights during emergency. During emergency, the right to move the courts for the enforcement of any of the fundamentals is suspended by the president. No. Okay. When the emergency is declared on the ground of war or external aggression, then enforcement of Nightingale is suspended automatically. Yes. Answer is 2 only. Consider the following statements. Residuary power vested in the Union or in the accordance with the provisions of the Government of India Act of 1935. No. It is Canadian. 1935, residuary power with whom? Governor General. In concurrence sphere, when there is an overlapping of law between the Union and state legislature, the Union law prevails. Okay, done. That is 1 only. So question is incorrect. Okay. Consider the following statement regarding expansion of legislative power of Union legislation, state legislation in the national interest. Okay. The residuary, what is the question? 24, sorry. The Council of States declares such resolution by 2/3 of majority of present and voting? Yes. 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 What is wrong in it? Rajya Sabha only will pass 249. That is 249. Yes. It is. What is wrong in the statement? I don't understand. I could not actually comprehend the question. Okay, that is Rajya Sabha only, no? Council of States is the official name. Rajya Sabha is not the official name. The resolution shall have the power for 1 year beyond which it cannot be extended. That is Article 249. The first statement is Article 249. The second statement is resolution shall have the power for 1 year beyond which it cannot be extended. 1.5. 1 year. Then if it is not passed, 6 months. So second statement is wrong. Anyone wants me to explain? Very simple. Read 249. Okay. I'm just telling him. Oh yeah. Nobody get offended because I say something, because this is my style of telling. 249 says Rajya Sabha can pass a resolution, then center can legislate. If the center legislate, it can be there only for 1 year. And if 1 year is going to expire, again Rajya Sabha has to pass a resolution. Then it can be for another 1 year. If the Rajya Sabha does not pass a resolution, it does not immediately goes off. It has a life till 6 months. Okay. Consider the following statement regarding the expansion of, which of the following scenario the doctrine of pith and substance shall be applied? The court examines and declared void only the part of legislation which is unconstitutional but not the entire law. Doctrine of severability, Article 13. The court rejects the law because the legislature does not have the power to make law on the subject directly and hence cannot make law indirectly. That is the answer. What you cannot do directly, you cannot do indirectly. When the provisions of the law are so contrary and disconfirmed that it becomes difficult to do one without opposing the other. Those are all just an explanation. Judgment is given based on court pulling out the true nature and character of the matter to bifurcate it into appropriate lists. That is also not relevant for this topic. So next question is some what? Okay, next is 26. What? B. The president can what? What was the question? What is the question? I will see. Wait. Answer is Bombay. B. B for Bombay. The court rejects the law because the legislature does not have the power to make law on the subject direct. Wait. Answer is D. Delhi. Answer is Delhi. Answer is Delhi. Sorry. Consider the following statement regarding interstate water dispute. The president can establish an interstate council to solve interstate water disputes. Parliament. Interstate Water Dispute Act 1950 empowers the central government to set up ad hoc tribunals for adjudication of interstate river disputes. The decision of the tribunal would be final and binding on the states. Neither the Supreme Court nor any other court have jurisdiction in respect of water disputes. Answer is Bombay. 2, 3, and 4. That is the Act says. That is what the Act says. Supreme Court does not have jurisdiction. What they do is they go under the extraordinary power. Article 131, they take it. Even in because we have no other option, they go there. For example, Kaveri, Tamil Nadu, Karnataka dispute, they have passed an order. Karnataka does not obey. They don't have the power to implement it. Even if you go there, they say we cannot implement it. Then you have no other option than to go to Supreme Court. After that is not wrong. That is final, unbinding. When I don't obey, what should I do? So Supreme Court does not have authority. That is Article 263 categorically says courts cannot interfere. But when everybody is in or disharmony, nobody is obeying anybody, then Supreme Court automatically gets the power because of its inherent power to adjudicate. So it does not have the power. Supreme Court refused to take up Tamil Nadu, Kerala, Mullai Periyar dam issue sometimes. Sometimes they take. So it is basically an extraordinary jurisdiction and they want to take, they will take. If they don't want, they will say go there and decide. First time when Tamil Nadu came before Supreme Court for implementation of Kaveri Tribunal, said go there and come. So it is an extra, but they don't have authority. They don't have authority to interfere into what is happening within the state legislature. Does not they interfere and say video cast the voting process? That does not mean court has the power. After Kesananda Bharati case, court has every power everywhere. For providing complete justice, to avoid travesty of justice, to ensure free, fair delivery of justice. Okay, so like that, they have their own reasons to say when it is so, when it is not so. So answer is 2, 3, and 4. Which of the following are true about aspirational district program? What is the answer? If you have kept 1, 2, 3, 1, 2, 4, you have got confused. I did not keep 1, 2, 3, 1, 2, 4. It was priced by UNDP. Okay, it was priced by UNDP. So it is coordinated by Niti Aayog. All other things are fact. Aspirational district program is also a mains question. Remember, nowadays, current affairs is for at least 2.5 years for mains. Can you understand? At least 2.5 years for mains current affairs coming right from 2019. Current affairs is not just current affairs. Current affairs is historical current affairs. Oh yeah. Prelims also. Yes. Yes. Consider the following statements on Central Bureau of Investigation. Both CBI and NIA are statutory bodies having jurisdiction across India. Why? CBI is not a statutory body. CBI is an body created by executive resolution for implementing Delhi Special Police Establishment Act. If the general consent given for CBI in state is revoked, the jurisdiction of CBI in that state is nullified. Yes, no, yes, no. No. Prospectively nullified. So there are two aspects to it. If the general consent for CBI in the state is revoked, till it is being revoked, those incidents which happened, okay, for that particular period, for example, immediately after that, Andhra revoked, West Bengal revoked. Remember when the arrest of commissioner happened? Tamil Nadu revoked. But Supreme Court said, yes, you can revoke it in the West Bengal case, but it is only prospectively. Year after, Supreme Court cannot come. Whatever things happened till 2019, CBI can come. After 2019, it cannot come. Okay. Wait, I will read again and come. I'm both the same. That is not the general consent. It is nullified. No. Answer is neither one nor two. Consider the following statements. Consider the following statement regarding relationship between center and the states. If a law made by the state legislature and concurrent list is repugnant to the union law, it can be made executable in the state with the president assent. That is what recently happened with regard to the new Land Acquisition Act. Every state had their own Land Acquisition Acts. New Land Acquisition Act has come and a lot of projects got stopped. So what they did is you want to turn it off. Pass it there and ask them to. Anyone has to go, no? Say for some time, pass it on. So turn it off and give it back. So if that is the, so when the new Land Acquisition Act came, most of the state government passed a resolution and wanted the consent of the president, and president gave it. And now what happens is the compensation is only with the central act. Next, the Constitution 42nd Amendment Act. The subject education was transferred from state list to central list. Both 1 and 2 are right. Consider the following statement regarding constitutional provision relating to trade, commerce, and intercourse. First is right. Second is wrong. Third is right. First is Article 302. Second is Article 304. Third is entry 3 of list 3. Essential Services Act. Okay. Can you see there is a difference in this question paper from last question paper? What is the difference? Exactly. That is what I want to make a point. So one strategy of attending the examination is you must understand what is a lengthy paper and what is a short paper. So there is no easy paper. Yes. So that you will not get stuck up in, because lack of time management will not happen. So this is exactly a lengthy question paper. That was exactly an ordinary question paper. That is what I just want to say. So reading all this, and many areas, lengthy statements, all 4 would be right. That is typically a character of lengthy paper. So when you guess, you can guess all the 4. Like that, yours are in rights. We'll talk about the strategies as days come. So answer is 1 and 3. What? Which of the following statements regarding state autonomy is correct? Answer is Bombay. So no need of discussion in that. So wherever we need to cut short, we'll cut short. Consider the following statement. Very beautiful question. What? In case of political deadlock, like lack of majority in legislature may lead to make the president as the ultimate responsibility of the state. Example, West Bengal, it's not West Bengal, Bihar, when Nitish Kumar became the chief minister, then Maharashtra temporarily, Tamil Nadu sometime. Yeah, so the governor can proclaim president of the state when there is a constitutional deadlock. No. So answer is one only. What? There is a difference between a failure of constitutional machinery and constitutional deadlock. For example, when Godhra incident happened, Prime Minister Narendra Modi was then the chief minister of Gujarat. He resigned and wanted to conduct the election. Then Lindo, who is the election commissioner, chief election commissioner, said we won't conduct election because there is a displacement of minorities. So that will disturb the electoral roll. It is an example of constitutional deadlock. Then it was referred to president. When president referred to prime minister referred to president referred to 143. That is a constitutional deadlock. Not necessarily 356 must come. In Tamil Nadu, when Jayalalitha died, and there was a defection of 18. And there was a confusion on that. Then again, that is a constitutional deadlock. So constitutional deadlock may happen at any point, anywhere. But constitutional machinery failure is the only ground for 356. No decision can be taken. Yes, when there is a clash between two articles, when some articles cannot be implemented, it is a constitutional deadlock. Lack of the many state governments does not want to implement CAA. Is it not a constitutional deadlock? Kerala files case before Supreme Court for under Article 131, original jurisdiction. It is a constitutional deadlock. Political deadlock is different from constitutional deadlock. Political deadlock is nobody has majority. Example, we are given the question, like lack of majority in the legislature. Yes, what happened in Bihar? Nobody could form the government. What happened in Maharashtra recently? Nobody could form the government. Then who has to become the head of the system? President. Yes or no? Primacy we must give. But there will be situations where political deadlock does not allow them to do. No game. The governor has the discretionary power in recommending the president's rule in a state. President rule in a state can be revoked by the president only on the recommendation of Council of Ministers. One only. Next. The parliament can enact law in the state list when one or more state asks for all states. If the state wants to adopt such legislation, it can do so by passing a resolution of the legislature to that effect. Which question? 34. Since independence, no states have asked the parliament to legislate in their subject. Incorrect. Water Pollution Act is a very great example where Assam and Bihar asked, Gujarat adopted it, and Haryana adopted it. Water Pollution Act is an example. So answer is 2 only. Next. Consider the following statement. When the emergency is declared on the ground of failure of constitutional machinery, the state legislative assembly is dissolved. No. Put into suspended animation. A law made in the state subject by the parliament during the period of emergency is coterminous with the duration of emergency. Incorrect. Once a law made during the course of emergency, it will be there. If the state does not want, they can Amend it. But read it fully. Emergency on the ground of failure of constitutional machinery. Read the statement fully. When you read it, okay, you have to derive a meaning out of it. Last class advice, same advice. Too technical, too microscopic interpretation. You read the full statement and justify your answer. When the emergency is declared on the grounds of failure of constitutional machinery, what will you understand? It has to be in correlation with the statement one only. This is a fundamental understanding reading principle. That is what I would say. Or else I will give you the mark. You want? Yes, I'm just telling you. This is and I will take you questions like that where UPSC questions are very ambiguous. I will just show you 2 or 3 questions in the next class for you, for the sake of you. What? Many. The same question. The protector, savior of constitution. President, Supreme Court, Prime Minister, Cabinet. For me, all the 4. If you know law, all the 4. Then another question is right to property. Constitutional right, fundamental right, legal right. It is a legal right, but they gave key as constitutional right. Right to vote. Okay, so you have lots and lots of ambiguous questions only from polity. I can also show you in history. I can show you in geography. 15 years, I am practicing UPSC question. 6 years I attempted every year. Yes. I will give you 15 minutes every day where you can tell what all you know. No, don't mistake me. He is a very good associate of Aram right from our first demo. That is why he has come to Tamil Nadu. He has read in several institutions in Tamil Nadu. He knows us there itself. So I'm just taking a liberty with him and I sometimes mock it. He takes too much of liberty than what I take. Okay. So we'll go to this next question. Which one of the following is not possibly affected during the national emergency? Separation of power. Which of the following matters? Where? Here? Allocation of finances, they can change. Naturally, what is the grants given by the center? During emergency, they can change. During any time, they can change. But is there any power of judiciary being curtailed? Or legislature being curtailed? Or executive being curtailed? Separation of power is the best answer. Allocation of financial resources can alter. No doubt. It can alter. In which of the following? That is the difficulty. Sometimes the question is that is how we also set the question. We take so much of time where you get confused on what to apply. That is why I say apply the situation. There is a concept of reverse engineering and answering. When you get confused between 2 choices, see the least choice. For example, 42nd question, I will tell you. In 42nd question, you would have got confused. Okay, I will tell you when it comes to 42nd. Come. Yes? Yes. In which of the following the matter, the center is empowered to give direction? All the 3? All the 3? Any doubts in it? Consider the following statement regarding the veto powers. Yes, same question. Sorry question. Consider the following statement regarding the Council of Ministers. The Council of Ministers enjoy the term till they have the pleasure of President. Council of Ministers does not enjoy the term. Okay, come. Anyway, there is 2 choices. You go for it. Okay, but how will you, well, let us see how you arrive for answer. The strength of the council of ministers should be less than 15%. It should not exceed. There is a difference between should not exceed and less than. Less than 15% is less than 15. Should not exceed is you can up to 15. The council of ministers is collectively responsible to Lok Sabha. Correct. The Prime Minister appoints and allocates portfolio for council of ministers. Why? Does not appoint. Tell me the answer now. 1 and 4, naturally. Because 1 and 4. I will tell you why. Sorry, 2 and 4, 2 and 4, 2 and 4. Sorry. 2 and 4, 2 and 4. We'll go. Which of the following statements incorrect regarding ordinance making power of the governor? Delhi. Wait. I just reading. Fine. Answer is C. Not from the date of issuance. 6 weeks from the date of reassembly. Not from the date of issuance. Okay. Can you understand what I say? There is a difference between issuance of ordinance and reassembly of the assembly. The governor cannot issue ordinance in case of bill which contains character of money bill is the general rule which is in practice. So in money bill, they won't go for ordinance. For example, a budget. A money bill is something which is fully of character of spending of money or making money. So like that. Actually, in practice, they don't do. Constitutionally, there is actually no bar. For example, you can make ordinance on tax laws. Tax law is fundamentally an money bill. So in ordinance, can you promulgate ordinance on tax laws? Yes. But the fact is that Supreme Courts and the Constitutional Convention which we have is that it is a money bill must get the approval of people. For example, recently in private member bill, when this preamble was being introduced, it was objected on the ground it is of the character of a money bill, it should not be taken up as a private member bill. Remember. So if it is a money bill, whether private member can make a money bill? Yes. But generally in convention, they don't do a money bill because it involves expenditure of the government. When it becomes an expenditure of the government is responsible to the people for the expenditure. So it is not supposed to be done without the approval of parliament. Because 265 bars it. No tax can be levied without the authority of law. So technically speaking, money bill should not be given on ordinance. By virtue of the power we have, they sometimes attempt to do, not at the state level. They have done it at one or time, 2 times at the central level, especially when it comes to amendment of existing financial acts. So most appropriate is C only, no? Okay. But that the fourth point is actually wrong statement as far as. Yeah, that is what I say. Actually, answer here I can accept if it is C or D, both. But C is actually most appropriate. C is on the face of it. D is on practice. This is how it goes. Actually, that is why I gave you certain examples of what happens in polity, and every year that happens. Only to make you believe, I will list at least 20 questions from UPSC where you will not have real answers. We have a list of that also, like practice of the past. I have shown. Did you saw in the booklet? Exact questions would be repeated every 10 years. Like that, I can also show you these kinds of most ambiguous questions. So you should not mistake us that it is being done to irritate you. It is not being done to irritate you. It is only to embarrass you. Yeah. The highest formal authority in India is President of India. This question actually, what happened? Yesterday, this question, I corrected the third level, where original statement was, if I am a vice president, if a person is a vice president acting as a president, his removal is by means of impeachment. That was the original statement. Actually, it is not true. The original statement is that if I am a vice president acting as a president, even if I do some wrong as a vice president, acting president, the removal should be by that of vice president. Exactly. So that was the original statement I kept. Somewhere it got mistaked and the question got little collapsed. The question is fine, but the key which we have is different. So I'm just apologizing it here. The answer is 1 and 3. But actually 1, 3 and 4 is right. What do I say? Answer, original answer right is 1, 3 and 4. You don't have a choice. So you will take 1 and 3. 2 is wrong. 2 says it's direct election. That is wrong. Yes, acting president. Yes. Answer is 1 and 3. The key is wrong there. I just want to tell the key is wrong. What is right in the statement is V.V. Giri, J.T. and Muhammad Hidayatullah were acting presidents. So Hidayatullah was the Chief Justice of India. What I want to say, what I say 4 is right is both of them, all the 3 were only the acting presidents, and Hidayatullah was the only Chief Justice who acted as president. Okay, answer is 1 and 3. Consider the following statement. An ordinance issued by the president can be retrospective. Yes. What kind of it is the logic. Ordinance issued by president can be retrospective, but not criminal legislation. Tax legislation can have retrospective effect. That is because, ex post facto law and fundamental right. No criminal law can have a retrospective effect. Next is the president can issue an ordinance related to amending a tax law. Yes, that was the discussion I had with him. The power of president to legislate by ordinance is coterminous power of legislation. It is a coordinate power, as he says. It is a coordinate power, not coterminous power. Coterminous means, or parallel means, I must have as you also have. It is only when the president, when the house is not there, they will have. Can you understand what I say? Yes. Answer is 1 and 2. I have this difficulty. I see here, I see there. So I get confused on choices. Consider the following statement regarding union executive. The rules for transaction of business of Government of India laid down by the President. Article 77. Article 77 is the basis for portfolio system. Everything happens there. There are 2 rules. This was asked by UPSC previously. Don't think I'm going too technical. 2016 question. Transaction of business rule. There are 2 rules in Government of India. That is the fundamental. Transaction of business rule, allocation of business rule. Transaction of business rule will say which ministry will look after which function. Allocation of business rule will say which officer will sign which file. For example, files above 5 crores has to be signed by the principal secretary. Files above 3 crores has to be signed by the joint secretary. This allocation happens by means of allocation of business rules. Can you understand what I say? There is a difference between allocation of business rules and transaction of business rule. Question has already been asked on transaction of business rule in UPSC. So remember, there are 2 rules, and that is transaction of business rule is with regard to the business of Government of India within allocation of ministries, whereas allocation of business rule is with regard to offices. Answer is, what was the question? We will see the question. Rules are not Prime Minister, it is President. It is right. Only 2. Right, there is some. Under SLP matter can be appealed to. Yes. Yes, Priyanka. So then, which of the following is not the duty of Prime Minister of India? Wait, I will say C immediately as you say. Then people will come and say, no, Bombay is Article 78, all. If the president C only. Yeah. D is 78. If the Prime Minister, if information is being, if a file has been given to the president and president sees it and he believes that it is not done by the whole council, 78 mandates it to be done by the whole council, then he can ask the Prime Minister to say, go back, get the approval of all and come. If there is more than one party is taking claim, the composite floor test can be conducted. Yes or no? The new concept was proposed by Supreme Court and the first composite floor test was held in Maharashtra. Maharashtra it was in 19. Karnataka it was in 18. And there are several states which had happened. Originally it was proposed by Supreme Court in SR Bhumikwas in 1994. Karnataka did not go for composite floor test. It only propounded the concept. Okay, in 2005 it was in Jharkhand. Several states, in Tamil Nadu it happened. In Haryana it happened. So, in 2016, Harish Rawat of Haryana, okay, their composite floor test happened. So, when two parties claim the stakes, one floor test will happen. Whom do you support? That can be by means of secret ballot. That can be by means of raising hands one after the other. How many supports DMK? How many supports JDMK? That can also be done. So that was recently happened in Maharashtra. Okay, composite floor test was ordered. Then they said, we don't want to go for the test. You take it. That is how all happened. So answer is A. Disputes of president election will be solved by Election Commission of India since they conduct the election and verify the qualification. Supreme Court. Disqualification of MPs can be decided solely by the President of India. Since he appoints MP. Wrong. It is, tell me, where all Supreme Court can decide, President can have discretion, we spoke. Where all President act on 74, we know. Where all President has to act on the advice of other than Council of Ministers and not at his discretion. Can you understand the question? The question is simple. Tell me instances where the President of India cannot act as his discretion, need not listen to the advice of Council of Ministers, but should listen to the advice of somebody else. No, where in Supreme Court? 103. On disqualification of members, President has to refer it to the Election Commission and do it. Example, Jaya Bachchan. Next. No. A pre-independent. Okay, fine. Take it. No. Next. Article 317. Supreme Court's advice on removal of a UPSC member. Okay. Then, wait. 149. On audit, pattern of audit, what the state government and the central government must have on the advice of CAG. Okay. Then collegium and all are not explicit in the constitution, no? I am telling something explicitly in the constitution. So, and as far as that 143 is concerned, when I only refer, the Supreme Court's advice is binding. If I don't refer, can you understand? So if I refer and ask Supreme Court, please give me the advice. There also, the advice is not binding. It is binding on the Supreme Court to give advice. Can you understand what I want to make you understand? So, yes. That is what withholding the bill is. We don't have a pocket veto. Can a money bill be withheld? Yes. What will happen if he withholds? Public opinion. Yes, that is pocket veto. You don't generally do. It becomes very sensitive. So pocket veto on a money bill is not prohibited, but not advisable. Disqualification MPs can be decided solely. Answer is neither one nor two. The Constitution does not contain any specific procedure for selection and appointment of the Prime Minister. The Constitution does not require that a person must prove his majority in the Lok Sabha before he is appointed as the Prime Minister. Answer is, consider the following statement regarding presidential address in Parliament. It is constitutional mandate for presidential address on first sitting of legislature every year. Here, don't ask me why not Lok Sabha or Rajya Sabha. Okay, legislature understood to be. The presidential address under Article 87 to the Parliament was based on British system. Then what? Presidential address every year is based on the Convention of Britain. That is next, 86. The right of president to address and send message to the House under Article 86 is based on American model. Yes. Last time I confused by 87. I know. That was last time. Not this time. No. Oh yeah, we know your psychology, no? We have a pleasure in doing that. Consider the following statement. Answer for that is all the three. When I want you to know certain rare facts, I will tell all the statements as right. That is my style of setting the questions. The collective response is mentioned in the Constitution. Judicial review is defined in the Constitution. Basic structure of our Constitution is a result of due process of law. Then answer 1 and 3. So that is fine. Those who can leave, I will send in doctrines of Constitution, which is very good. And I want to actually show something for you, but you all are in a hurry. Next class. Okay. Oh, that only you are waiting. Then I will ask and then sir to come. Whoever wants to go can go. Many questions wrong today. That is fine. But have you not learned something? That is what. Doctrines. So I will tell you, and Aram IAS Academy already told you that we are known for our assistance to the students. You can tell us whatever you want. And this discussion is very important. Next week, history faculty will come. You will see what is the content of history faculty. Then after geography faculty will come, he is also like that. You attend the discussion, that will be more actually giving you a real understanding of what the subject would be. And this is the doctrine we published some 2 years back. This was our first ebook during COVID time. So doctrines of Constitution, all these doctrines are there. And this I will share in the group. So every doctrine we have explained properly. And you will not believe, every doctrines have an article, every doctrine is supported by the article in the Indian Constitution and also the judgment which is covering it. Mains questions are very commonly come. So these doctrines I would be sharing with you. And this coming rush through series. And for this prelims, we are actually making ready certain current affairs which should be very difficult for you. We have a lot of issues for mains, prelims and others. Last year we had released one do not miss series on answer writing for mains. You will not believe, out of 16 questions from governance, 11 questions, I won't say it is reflection. You can see now, most of you now are part of our Telegram group. No, in Telegram group, December 15th, we released do not miss series. Okay, in December 15th, we released do not miss series. And January 7th, I compared what was already released and what was the UPSC's question. And it was not actually reflection, the same question, the same, near same question. I will also share that. What I will do is I will also share the link of that December 15 and also what I shared as comparison, so that you'll have the trust of what it is. I am telling on the last test I said We just want to be part of Delhi system only because we want to know whether we stand the national test one. We know that we will stand, but we need to convince you that, because you all will have the fear that who are they. So we don't want to have that doubt for you. So I'm just telling us and this is for our 2022 prelims. These are all, last year you see there is a change in the trend. Do you accept? What is the change in the trend? Questions from personality is coming. Questions from sports is coming. So what you need to do now is you have to accommodate to it. And this is not new. Take 2001 to 2006 question paper. You will find questions on sports. And 2000 post 2006 they have left it. So UPSC have certain patterns. We have to follow with it. We may come, it may not come, but we don't know. But we get adopted to it. We try to adapt to it. This is personalities in news. How do we do? Wait. This is index. जी வாங்க ரைஸ் பண்ணுங்க. ஸ்லோ ஆயிடுச்சு. ரைஸ் பண்ணுங்க. ஸ்டக் ஆயிடுச்சு. வெளியே போயிட்டு வாங்க. Close it and open it. If it is a personality, what we do is Pandit so and so, context of what it is, on which day it has come in newspaper and a news about him. Pandit Reva Prasad Dwivedi. What is the context? When it came in the news, source PIB. Similarly, okay, this is an historical personality. By why it came in the news, the last Begum Bhopal came on death anniversary of Begum was observed. That come in the newspaper, it is Indian Express. So like personalities on it, species coming. It is on species. Cut பண்ணி திருப்பி open பண்ணு. This is for species in news. This is also because every question is there from species, no? Every year. So see how it has been done. For example, this is a species context and where it has got in newspaper April 26, Indian Express explained it. Then wild balsam species, context reported from Kerala. So it is reported in Hindu. So we have this, and this is mermaid species of algae discovered, where in Andaman Nicobar. So news on earth. This is how environment questions come, and this is for then sports comes in. And we have another compilation called as Confluence. Confluence is every day we release Confluence. Now it is 14th day. From March 1 we are releasing it. 7 subjects, one current affairs topics. We are releasing it for 100 days. So 700 topics we release. Naturally 1 or 2 questions, or at least 5 questions, or maybe 2 or 3 questions. This is on sports personalities. Cut பண்ணிட்டு. I don't know why it is doing like this today. I don't know why it is happening. This is on sports like this, same way. You know, you are going to share in the group actually. We'll put a timetable for it and do. And similarly, we have confluence. Confluence in காட்ட முடியுமா பத்ரு? The sports. Okay, this is better. Like this. So she is one page. So Hindu. Those days when you used to be candidates, what we'll do is first we'll receive in those days only Hindu paper. We used to read. We'll first put the paper back. From back we'll come. Those days, that is how generally civil service candidates read, because concentrating on sports continuously will get 2 questions those days. So this is how it is. Confluence. Confluence is also very good, but you need to put all your efforts to read on that. So the concept is this: 100 days, 700 topics. அது மாதிரி போட்டுருக்கலாம் PDF இருக்கு. I don't know why it is happening like this. Cut பண்ணுங்க. Polity, Supreme Court and environmental matters, art and cultures, painting in India, geography, one sun, one world, one grid, economy, Pandora papers and tax havens, environmental, Central Asian flyway, science and technology, so and so. Current affairs basically also will put. You will just why in news, because this is the reason. Then introduction, provisions regarding it, and what are some important judgments on environment and what are the principles they have derived. Then history, Madhubani painting, Batik painting. So like this, because every context we will just do. So we are releasing it. That is already there in Town Hall. If you search in Town Hall, everyday Confluence would be there for 14 days. You know, you'll also start sharing in our test batch group also from this day. Because if I put all the 13 at one day, you will not touch anything. Yeah, so I will do it that way. Thank you. And whoever requires any help, you can ask us. And next test would be on Friday. And next test, next Monday, history. So 3 days, same subject. And you will understand that every faculty in Aram would be delivering the level which you would only understand that that would be enough for clearing your examination. And we are also planning to introduce a free essay module so that nobody is there in essay, and we are planning for free essay module also. So, but it would be advisable after prelims, no, not before prelims. Okay, fine, thank you.